Hello, my name's Deborah Bates. I'm a family lawyer at Pennine Law. I've been a family lawyer for 32 years, and we're just going to go through some frequently asked questions in relation to child arrangements orders.
If both parents agree on how and where a child is cared for, is a child arrangement order needed?
No is the short answer. The Children Act introduced what we call a no-order principle. Prior to that, when people separated or became divorced, generally there was always an order saying who the children should live with and when and how contact should take place with the parent that they weren't living with. The Children Act changed that and introduced a no-order principle, so where parents agree, the courts will not make an order. The courts get involved only when it's really necessary, where parents can't agree where the children should live.
Do I need a solicitor to decide who looks after the children after separation?
That's a really broad question because it depends on how the parents are getting on when they separate. Some people get on really well, some people obviously don't. So if parents get on together and they can agree on where the child lives and how often they see that child, then no, you don't need a solicitor to help you with the arrangements. Anything that you record in an agreement wouldn't be enforceable anyway, but it would be a record of what you'd agreed. So if there was a dispute further down the line, that might be helpful evidence if you did need to make an application to court. But it's better for the children if you can agree, because then you've got a flexible arrangement rather than a court order, which obviously is a little bit more rigid. So no, you don't need a solicitor, and we would always try and encourage you to reach agreement with your ex-partner and to compromise with them. And if you can't speak to them, we can do that for you. But if you can't agree, then certainly you can come to us and we can either refer you to mediation or we can negotiate an agreement for you.
Who can apply for a child arrangement order?
Anybody can apply for a child arrangements order. There's a variety of people and a lot of different circumstances in which it can be applied for. So the parents of a child can apply. Step-parents can apply in certain circumstances. Sometimes people who aren't actually related to the child can apply. If there's a case where a child might have been at risk in some way, and there are other family members who may want to look after that child, social care sometimes, if they don't feel it's a full care case and there's agreement between all the family members, that person can apply to the court and for a child arrangements order, for instance, if that child's going to live with them, and that's usually with the backing of social services, but generally it would be parents. Sometimes grandparents can apply. Certain people need permission to apply and certain people don't.
How long does it take to obtain a child arrangement order?
It can vary greatly. It really depends on the circumstances. I would say on average around 6 to 12 months, probably nearer the 6-month mark now, because the courts are geared up to try and resolve issues quickly. What used to happen years ago is that you would make the application, the court would make an interim arrangement, and you would go away for 3 months, test it out, come back and review it. The court are trying to get away from that now and what they will do is what we call a stepped order, which rather than keep going back to court, they will make an order that makes the arrangements for the children over a long period of time, and it can be for up to a year. But if there are safeguarding issues, so if one of the parents is taking drugs or there's domestic abuse, it could take a lot longer because there are other things that the court will need to look at in those circumstances. So it really does vary.
What steps should parents or guardians take when amending a child arrangement order?
Initially, I would say that they should speak to each other, and if they are in agreement, they can make an application to the court to amend the order by agreement, and that's called by consent. They can get a consent order. If they can't agree, they'll need to go to mediation If they can reach an agreement at mediation, again, they can go back, and whatever that agreement is that they've reached, they can ask the court to incorporate that into the court order. It would be an application for a variation of the original order. If they can't agree and they've been to mediation and that hasn't worked, then they can make an application to court to vary the original child arrangements order, and the court will then make a decision as to whether or not that should happen or not.
Do the parents or guardians need to attend mediation before amending a child arrangement order?
Yes, if they can't agree, they would need to do that.
What are the main things parents or guardians need to consider before making an application to the court to vary a child arrangement order?
I think the most important thing, the court always approach matters relating to children from the point of view of what's in the best interest of the child. So you've got to be certain that what you want to change is in their best interest. If they can agree, if they're speaking, they can approach the other parent and try and reach an agreement on a variation. Again, if that doesn't work, they can try mediation, or solicitors can often negotiate an agreement when mediators can't. Mediation's brilliant, but both parties have got to be willing to compromise, and if they're not, sometimes it can be quicker and more efficient really to instruct a solicitor. But I'm not saying you shouldn't mediate, but it just depends on the circumstances.
What will the court take into consideration when reviewing an application to vary a child arrangement order?
The main thing is the welfare of the child, and is it in their best interest. There is a list of things that the court look at under the Children Act, so the effect any variation would have on the child. They will look at what the child wants, depending upon, their age and how mature they are for their age, probably more so. They'll look at how long it is since the order was made. So if you go to court and you get an order in June, you're not going to be able to apply for that to be varied in July unless there's been a really significant change in circumstances. So times when they might look at variation of contact orders is if one party's job's changed, for instance. So they might have been working Monday to Friday 9 to 5 and now they're working 4 days on, 4 days off. So and that might not fit in with the contact that was in place previously. Or if one person moves home, and the distance involved in travelling to see their child has now been extended. So it's those kinds of circumstances.
Why is it important to seek expert advice from a solicitor when amending a child arrangement order?
I think because solicitors have obviously got experience of dealing with this, we deal with lots and lots of different cases. So they can give you a really good idea of what's likely to happen when you go to court, if you go to court. Because that would always be my starting point. I would always advise, look, if you went to court, this is what could happen or may happen. And then it's for the client to make their mind up whether they want to do that. There's obviously a cost to it. And obviously we encourage clients to try and reach agreement directly with each other if they can, because that saves legal costs. And if not, to go to mediation or to allow us to negotiate on their behalf. We can often get an agreement between parties where they can't themselves, even through mediation, simply because we're saying to them, well, look, you can ask for that, but it's unlikely it's going to happen. And we can sort of arrange, we can negotiate a compromise in those circumstances. Because when people know what the limits are, I mean, we can't tell them exactly what's going to happen, but when they know what the limits are, then they tend to be more inclined to agree and reach a compromise and an agreement, and that saves costs. So, people do have this misapprehension, I think, of solicitors, that it's really expensive, and it can be, but we're here to try and reduce legal costs and to minimise tension, and that's what a good family lawyer will always do.